prenuptial agreement or a prenup is a contract between two people who plan to get married that lets them set out how their assets will be divided if the marriage ends. Prenuptial agreements are most commonly invoked in the context of divorce proceedings, but in Indiana, they can be structured to apply in the case of separation, death, and other events. For some couples, prenups may be an essential condition of getting married. We're eForms, the largest online database of fillable legal forms. In this video, we'll address Indiana prenuptial agreements, including requirements for a valid prenup, what information must be shared before signing, and what terms might cause a prenup to be set aside. Sometimes the decision to get a prenup will be obvious, but in many situations it won't be so easy and may require a tough conversation. Keep in mind that in some relationships, even suggesting a prenup could provoke resentment. Whether a prenuptial agreement is right for you will depend on the financial situation of you and your partner, your future prospects, any children or dependents you may have, and other factors. For some reasons, it may be best to speak with a financial advisor before pursuing a prenuptial agreement. First, the basics. What are the requirements for a valid Indiana prenuptial agreement? Indiana is one of many states that have adopted the Uniform Premarital Agreement Act, a model law that sets out rules for how prenuptial agreements work and how they are to be interpreted. Each state may make some modifications to fit the act of their needs, but the broad structure remains the same. Once you and your partner have decided to pursue a prenuptial agreement, it's important to be totally honest with each other about what assets and what debts or liabilities you may have. If it later emerges that one spouse was dishonest about this, that may be grounds for setting the agreement aside. Each spouse should have the opportunity to consult with their own attorney to prevent claims that one party was coerced into signing. In Indiana, prenuptial agreements must be written down and signed by both parties. Oral agreements are not allowed. They are meant to apply to people who intend to be married and become effective when the marriage becomes official, not when the document is signed. You may also hear prenups referred to as premarital agreements. Marital agreements, on the other hand, can have similar effects, but are documents created after a couple has been married. It's also possible to modify a prenuptial agreement, but modifications must be written down and require the signature of both parties. So, what can a prenuptial agreement contain? Couples have a lot of flexibility to structure prenuptial agreements. They can cover personal property or real property, including real estate located outside of Indiana. It can apply to property owned individually by either party or to property that they have owned together. The agreements can modify future holdings or obligations. For example, they can set out what will happen to the proceeds of an insurance policy. They can also limit or even eliminate the obligation of one partner to provide spousal maintenance, also called spousal support. However, there are some things that Indiana prenuptial agreements cannot contain. They cannot limit future child support, and they cannot obligate someone to violate the state's criminal laws or public policy. The agreement should also not be overly unfair to one side. Such agreements are called unconscionable, and even otherwise valid prenups may be set aside if a judge deems a provision unconscionable. Prenuptial agreements can provide certainty in challenging divorce proceedings. To find a template for a valid, enforceable Indiana prenup, click the link here. And don't forget to subscribe to keep up with important information about business, property, and other legal topics.